One of the few things that the president of the American Law Institute gets to do all by herself is choose the speaker for this luncheon. And it's always really hard because when you look at the list of everybody in the class, there are such incredibly able people who have accomplished such astonishingly wonderful things. But in this case, given the time, it wasn't that hard for me to immediately settle upon somebody who is right at the forefront of one of the most challenging issues facing not just the profession, in my view, but the country. And that is the future of legal education. Phoebe Haddon, I'm happy to say, has been a friend of mine for a very long time. I'm honored to be her friend. She, unlike me, I had nobody in my family that had ever been a lawyer. Phoebe is the fourth generation in her family to come to the law, and so she has a genetic predisposition to solving these problems. She has been very active in legal education nationally. Sometime earlier this year, there was a list of the 25 most important people in legal education in America, and Phoebe was one of them. I'm proud to say that was after I'd already asked her to speak. And her intellect is well known. She went to Smith College. She was vice chair of the Smith College board until she left to become the dean at the University of Maryland Law School, where she has been an incredibly innovative force nationally and also at that law school. She decided that she'd had enough fun as a dean last year, or maybe the year before, and indicated that she would retire from the deanship at the end of this year and that she would take a year-long sabbatical. That lasted about 20 minutes because it was announced a few months ago that Phoebe was going to become, on July 1st, the chancellor of Rutgers University's Camden campus. So let me welcome to the podium my friend, who I guess I'll have to call Dean Chancellor. Thank you.
It's a pleasure to be with you this afternoon, and I have to say that one of the advantages of being a 25th year member is that you're sure to meet old friends and new friends. And in this room, I have so many old and new friends, including some that date back to about 4 decades ago. So I only say that quietly in this room. But say that I'm also tempted to just adjourn and have us all have a nice conversation and call it a great afternoon. But I do have something very important to talk about, something that I feel pretty passionate about. So I'm going to talk to you about the justice gap. And most of you know that that's a term that now really starts to capture the fact that according to our best calculations, and it's really just a guess at this point, there may be about 100 million people in our country who don't have access to an attorney or needed legal services. 100 million people. Now, some of those touched by the justice gap fit our traditional expectations. They were ones I became very familiar with as a law clerk. They're indigent or poor people charged or erroneously convicted of criminal offenses. But as the justice gap has grown, it's come to include individuals of moderate income, including members of the middle class, and those who are struggling to resolve conflicts on their own. Trying to make this go. Maybe it's not. If it won't go, it's quite all right. My first glimpse of the magnitude of and complexity and urgency of this problem really came several years ago, quite frankly, soon after I became dean at the University of Maryland Carey Law School. Now, what do I have to do? Okay, thank you. When I listened to a panel discussion we hosted at the law school, I heard Paul Grimm. Many of you may know him. He was then the magistrate in Maryland, but now he's a district judge. He described his struggle to mete out justice to litigants who appeared in his courtroom without representation. It was immediately apparent that Judge Grimm had a courtroom that wasn't unique. In fact, his fellow panelists, several local state judges, were embroiled in the same problem. All of them candidly described the complexities of attempting to level the playing field, as they put it, for pro se litigants with do-it-yourself manuals, translating and simplifying court rules, and making their clerks and other people responsible for some of the things that they were confronted. The judges' stories were heart-wrenching because of the plight of the litigants, of course. They were also disturbing because the judges were clearly frustrated trying to weigh the competing rights and interests at stake in these civil controversies, not criminal. And the stories were especially disturbing because they were taking place in Maryland, a recognized leader in addressing the problem of access. Thanks to the vision and commitment of Robert Bell, the recently retired chief judge of Maryland's highest court, the state has a 46-member Access to Justice Commission, one of few such commissions that's connected to the judicial branch and thus able to have an immediate impact on the court practice. And one commission member, Pamela Cardullo-Ortiz, has said, "The hallmark of a healthy democracy is one in which individuals can exercise their rights to enforce the protections, privileges, and opportunities available to them under the law. But they can only do so if they have access to the justice system through which their rights are enforced." Maryland has taken steps to increase access to justice and protect democracy. For example, they have self-help centers in all of the circuit court locations and district court so that people can represent themselves. They have a network of public law libraries they call the People's Libraries, and a network of local pro bono committees. All of the 36,000 lawyers in Maryland have to report their pro bono activity. When interest rates plunged a few years ago, they passed legislation to increase the surcharge on court filing fees to fund the depleted lawyers' trust accounts, or IOTA, which had supported the civil legal service providers. During the recession, it trained hundreds of lawyers in how to provide pro bono help to homeowners at risk. And this fall, the Access to Justice Commission is going to consider a report on how to implement a broad right to counsel in civil matters. Despite this work, 60%, 60% of domestic cases in Maryland have at least one self-represented litigant. In 40% of those cases, both parties are unrepresented. Fully 3/4 of domestic trials have at least one participant without a lawyer. Sadly, this lack of representation is replicated in many other states these days. In Massachusetts, in the Supreme Judicial Court, 75% of parties in the housing, family, and probate courts were representing themselves. In New York, 99% of tenants were unrepresented in eviction cases, and 97% of parents were unrepresented in child support proceedings. 60% of homeowners in foreclosure are unrepresented when they're attending mandatory settlement conferences. There are other disturbing signs of underrepresentation, including some national figures. In 2009, about half of all appeals filed in federal courts were done so without representation, largely because litigants were unable to afford counsel. And we now know that approximately 20% of the U.S. population is by law eligible for legal representation, but of these 60 million people, about half, or 30 million, who actually seek legal counsel are denied it every year. Why? Because state and federal programs are underfunded, as many of you know, or simply because no pro bono lawyers are available. Those turned away are overwhelmingly women, veterans, the elderly, and families with children. So according to Professor Deborah Rohde of Stanford, approximately 80% of the legal needs of poor individuals and a majority of the legal needs of middle-income Americans now remain unmet. Millions of people cannot afford to pay the hourly $200 to $300 rates often charge for routine legal services. And I want to point to some other areas that point really dramatically to this problem. First, the justice gap is taking place at the same time that pundits talk about a glut of lawyers. By these critics' estimates, we have been producing about 20,000 more new lawyers every year than the market demands. Now, I'm going to accept that assertion only if we are describing the market as restricted to organizations that provide permanent, full-time employment at healthy six-figure salaries to individuals with newly minted JDs. Otherwise, I'm going to take issue to that point. True, there aren't enough of these kinds of positions. They began to evaporate a few years ago, just as I became dean, and escalating costs of law school led students to incur increasing amounts of debt. The fact is, we have a bitterly ironic mismatch. On the one hand, we have thousands of highly trained but unemployed or underemployed recent law grads. And on the other hand, we have millions of moderate and lower income people who need legal counsel and others who may not know they are at risk because of self-representation. So our challenge as a profession and a democracy is to change that, to redistribute the skill of legal service providers to a significantly larger portion of our population. But at the same time, we must contain law school costs, offer loan forgiveness through federal, state, nonprofit, or law school endowed funds, and explore changes in fee arrangements and other innovations, such as low bono and unbundled services, all steps that will enable young lawyers to engage in access to justice work. These are tall orders. The second point worth making is that there is no uniform national compilation of statistics on unrepresented litigants. None. Data from states like those I've cited may appear random and thus not comparable. Some of the figures are certainly outdated. I know that from looking at studies, but even haphazard reporting confirms that a national crisis exists. The absence of uniform statistical data on unrepresented litigants prevents us from fully grasping the dimensions of this access problem and the complexities of solutions that might actually succeed. I think it compromises our ability to really think very constructively and make sound strategic decisions. We don't know how to allocate scarce resources or which kind of initiatives ought to take priority over others. We need sustained evidence-based studies to inform our access work. For example, as Deborah Rohde points out, does access to justice mean access to legal services or access to a just resolution of legal disputes? They are different. Access, or the lack of it, is also a function of the population to be served. Unbundling services can reduce costs, but lower fees won't help clients who don't understand they have a legal need. Easily available documents and call stations for routine landlord-tenant disputes may be useful to immigrants or others who have language or literacy barriers. May not be useful to people who have language or literacy barriers. Even with inadequate information, it's obvious that our justice gap actually is a justice chasm, so wide and so deep that only the wealthiest individuals among us can bridge it. So, why the gap? There are signs all around us that our country's legal system faces serious problems that go beyond the costs and complexities of service delivery to the poor and middle class. Notably, we incarcerate more people than any other nation, and the majority of our inmates, as you know, are male and black. As Michelle Alexander author of The New Jim Crow, observes, racial bias can be linked to government drug policies, policy that's destroyed communities and drastically reduced the opportunities for the incarcerated ever to lead productive lives. It has an impact. And whether or not you agree with the perspective of those commentators that I talked about that talk about a glut of lawyers, it is apparent that structural changes are transforming the business models of our profession. So if you spend even a few hours reading things like the books of Richard Susskind, Paul Lippy, or Bruce McEwen, it's clear that we're in the midst of a transformative time, replacing a system based on the traditional law firm hierarchy and fee arrangements, perhaps with new approaches that are the consequences of technology, globalization, and cost-conscious clients. We don't know where that's going, but it's going someplace. And I heard a great NPR story on the way here, stuck in the cab, about Kodak. Remember Kodak? Innovation is what we need. I believe innovation through collaborative work from the bench, the bar, and the academy is critical to respond to these challenges. I also want to argue that law schools, and hear me out, my fellow academicians, law schools and the larger universities in which they reside should assume a more active role in defining the future of the profession and of legal education. Public institutions, given their history, mission, and responsibility to serve the citizens who support them, could lead the way in defining more clearly the causes of the justice gap and the strategies for bridging it. Now, I know that there are signs that the profession has begun to grasp the importance of the justice gap, particularly as it touches more people of moderate income and the middle class. It appears that the bar may be more receptive to innovative service delivery and willing to collaborate with law schools and public interest organizations in gathering the solid baseline access to justice data that I said is so critical. And in 2012, the ABA gave its annual award for access to legal services to a for-profit virtual firm in suburban Detroit that used of-counsel attorneys with existing practices to provide contract reviews and other common legal services to middle-class people who could not otherwise afford them. Their flat fees hovered in the 300 to 500 range, not thousands. At about the same time, after years of debate, the judiciary in Washington state created the highly controversial new category of legal service providers called limited license legal technician. These technicians can help with court forms, procedures, and pleadings. Although they can't represent clients, technicians can alleviate some of the more frustrating aspects of pro se litigation for both judges and unrepresented litigants. Now, some of these kinds of proposals are very, very controversial, and I'm not endorsing any one in particular. I'm just suggesting it's time to try some new things. The bar has also started to work with the law schools to address this mismatch, the daunting job prospects for many recent graduates and unmet need for legal services, by actively participating in law school incubators, firms, and other new venues for individuals needing representation. I'll speak just about a few of those. Maryland, for example, works with a local public interest law organization to offer Just Advice, it's called. It's a service that provides 30 minutes of legal advice and referrals for $10 at roving locations throughout Baltimore and across the state. Our students team up with practicing attorneys, many of them retired, who donate their time and provide one-on-one, simply advice to clients. Not legal advice, but simple advice about whether they have a legal problem or what they should do. The students manage all the business aspects of the program. They screen clients, run the office, and promote the service, and they're supervised by our faculty. The law school also runs an incubator program with Civil Justice, which is a network of small firms and solo practitioners who help train new grads how to serve low-income clients and successfully manage this kind of practice. This is a project that's similar to others across the country, and Rutgers Law School in Newark now runs a law firm staffed with recent graduates who've passed the bar and are supervised by experienced attorneys. The fellows at the firm provide a range of legal services at well below market rate to low and moderate income clients. I like these programs in part because they teach third-year law students and graduates how to manage a practice, work in organizations, and acquire the business school skills needed to support themselves. These are things that we have not helped them do in law school as much as we should, and we're moving in that direction. They also expose students to devices like sliding pay scales, alternative billing arrangements, and contingency work, and fee-shifting statutes that might be used in the future. Finally, the bar, law schools, and nonprofit organizations have joined forces to address lack of evidence-based empirical work on the justice gap, and that is critical. In 2011, the American Bar Foundation hired Rebecca Sandifer, a sociologist at the University of Illinois College of Law, to survey the patchwork of state civil work. The study found that geography is destiny. The civil legal resources available to an individual are determined largely by where they happen to live. In addition to Sandifer's work, the United States Justice Department also created an Access to Justice office in 2010, and I think many of you know about that. But in addition, Deborah Rohde, the American Bar Association, the Center on Legal Profession at Stanford, Harvard's Program on Legal Profession, created a consortium on access to justice, which is a committee, a group committed to promoting research and teaching on access to justice. Deborah is a vital contributor, but many, many law schools are now participating in this consortium. There are all positive, important steps like these that are working, or that are at least trying to address this issue. But many of them, and most of them, I should say, are comparatively small, isolated, and incremental. So as the dean of a public law school and soon-to-be chancellor at a public research university, it should not be surprising that I'm particularly interested in how law schools can harness the work of students and faculty in the social sciences and humanities to strengthen our law schools' roles in defining and successfully bridging the justice gap, and I'm looking forward to that. Here are some obvious departure points for law schools that build on their existing strengths. First of all, we know that we're communities of scholars, and we should be engaged in research that focuses on access to justice here and internationally, and search for new solutions, including the use of alternative dispute mechanisms and pay arrangements. This knowledge, combined with data-driven analysis of where the justice gaps are greatest, would allow law schools to conduct an access to justice audit of their curricula that went beyond clinical law to include things like securities, banking, tax and business courses, as well as transactional consumer law, all practice areas that not only touch on the middle class, but today now affect very poor people and the indigent. Law schools must learn how to better collaborate. There should not be duplicates of innovative clinics at the University of Baltimore, which is right down the street, and Carey Law School, which is in the same city. We need cooperative academic consortia like those I knew as an undergraduate, the 5-college program, and graduate and undergraduate institutions that work together in the Philadelphia area. So I've been encouraging other deans to think about those kinds of collaborations. Law schools are also laboratories. They could be what incubators or startups are to the technology sector, thinking outside of the box, exercising their academic freedom, but also their imaginations on behalf of the underserved. Using evidence-based research and with the assistance of courts, law schools should reshape their clinic programs to meet the most pressing needs of their communities, a benefit not only to the clients but to students who would gain practical experience addressing the most acute legal needs in a given geographic area. Research could also help us to identify best practices in service delivery. Finally, we must do more work as reformers and lobbyists to shine a bright public spotlight on the problem of access to justice, one that reaches well beyond our profession. For example, working with an ABA survey done in the 70s, this is the latest data, Rebecca Sandifer discovered that cost wasn't the only or even the predominant factor which kept people of moderate means from seeking counsel. Some people didn't know how to find a reputable lawyer. Others didn't recognize they needed one. Some were ashamed of going to a lawyer because they thought that going to a lawyer said that they had failed in some way. So we need to build on some of these strengths of law schools, use this kind of data, develop new data, and adopt new strategies. We also need, I believe, a vast public education campaign about the importance of law in our everyday lives. Adolescents need more than a basic civil course about the three branches of government and when to vote. They need that. But I'm also thinking about more deeply embedding into the schools and understanding of what law means. So I'm thinking sort of the large public health campaigns that got Americans to quit smoking or to some of us to lose a little weight or to help our children lose that weight, that one like Michelle Obama is pushing. We need to have something like that, and we have not anything remotely comparable to that kind of education. And clearly, millions of people do not grasp how law can be of value to them or their loved ones, and perhaps of a consequence of this education gap, or because of what the pundits have talked about and bemoaning our litigious society and devaluing the service of lawyers. They need to be reinforced and come to understand the importance of law. We must reclaim that pulpit. Once people valued our profession for the work of its practitioners. They didn't envy wealth or power. They admired lawyers' work and how it could protect or advance the lives of those who were neither wealthy nor powerful. But today, for many people, law is not power or even order over evil and anarchy. And many believe it has nothing to do with the poor or the marginalized. Many people would be surprised to learn, I dare say, even in America, that it was founded on the principle of equality and justice for all. For them, justice is merely an elusive phantom. Literally, millions of Americans are without access to justice for lack of financial resources, information, or will in the face of overwhelming obstacles, despite the fact that our nation was founded on this notion of justice for all. So I believe it's the responsibility of every lawyer in this room, and those of you who are not lawyers, to undertake the responsibility of delivering on that promise. And I'm willing to try, and I hope you will too. Thank you.
Well, I think in hearing the about-to-be chancellor, you understand what your role is now. And that is you've had 25 years of training at the American Law Institute, and now she has enlisted you in a new war. Yeah. Phoebe, I cannot thank you enough for this challenging and important talk, but I want to give you, and each of your classmates will receive this in the mail, your 25-year life member certificate.
Thank you very much. Thanks.
Thank you. I'm so proud of you. So, as always, these lunches are the most energetic and moving of any lunch I've had this year. We are now ready to adjourn, but let me tell you, this is something former Secretary Napolitano will understand. not at Justice Ginsburg's request, but at the request of her security detail. Will you all please exit out this door instead of the doors at the back? And I know that will slow you down a little bit, and she would be embarrassed that they asked it, but don't tell her if you would. I'd appreciate it. See you in just a few minutes.